following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricacies of marriage dissolution and adultery in Sri Lanka. How does the law go about this offence, and what are the means of justice available? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, today's topic is not something that we haven't covered on our program before, and that's on marriage dissolution and divorce. But specifically, when we have considered all the legal implications during the process of divorce, we haven't really had a chance to consider and discuss the legalities and the legal landscape surrounding a leading up to a dissolution of marriage by the courts. And to speak about this very specific but also vast area, we have someone that's very well suited for this specific topic, and that is Mr. Ian Fernando, attorney at law. Thank you very much, sir, for coming down to the studio here today.
You're welcome.
To explain this very vast topic to us. A bit of an introduction into Mr. Fernando. He has close to 40 years of experience at the bar, and specifically when it comes to this topic as well, he's very well knowledgeable, and he comes from an entire lineage of lawyers. So safe to say we're in very good hands when it comes to discussing the nitty-gritties and ins and outs of this very complicated area. So here's how we're going to approach this topic. First, we'll be talking about the fundamentals and the basics. I'll be helping us understand exactly where the law lies when it comes to marriage dissolution. Next, we'll be talking about the current context, specifically when it comes to how important the online activities and sphere is when it comes to relationships in general in Sri Lanka and the legalities surrounding that. And finally, what we can expect to see as reforms moving forward in the law of Sri Lanka.
Hi, I'm Nishal Ransingha. I'm an assistant lecturer for the Department of International Relations, University of Colombo. My question is about fundamentals. How is divorce governed in Sri Lankan law?
All right, well, without any further ado, let's get right into the details of this topic. Once again, thank you very much, sir. We have a lot to cover, especially not just relating to the legal education, but also a general consensus and understanding of marriage dissolution and the lead up to it as well. But before we get into the specifics that we wanted to delve into, I think it's important to give a bit of a preface into the law in itself. So can you walk us through the legislation that's already enacted and in place when it comes to the landscape of marriage dissolution in Sri Lanka?
Yes, in our Civil Procedure Code, we have a section for divorce, and that sets out the grounds for divorce, and that's also there in the marriage ordinance, General Manager's Ordinance, which also clearly sets out the three grounds for divorce. The three main grounds for divorce is, one is maliciously deserting the other party. It can be constructive or it can be just malicious desertion. The other one will be where you're caught to be under adultery, and the other, there should be sexual impotency of the one party which is incurable. Those are the three main grounds for divorce. Though some people think that cruelty may be a ground, cruelty was a ground under the Canadian law. Under General Manager's Ordinance, cruelty is not a ground for divorce.
And now I want to get to a very curious question that we have now, mentioning the three areas that divorce can be recognized, specifically when it comes to adultery as well. Now, we have done previous segments relating to divorce in itself, but when it comes to the actual act of adultery or committing adultery, when there is a conversation about maybe an extramarital affair, how exactly does the law go about giving a right to divorce the other spouse that has been taking part in such activities? Is it clearly stated?
Yes, it's law is developing by the day. And earlier we didn't have a law where without a divorce case you can file action for adultery. Now the law has developed. So you did not file a divorce case to file for adultery. You can just file a plaint for adultery and ask for damages. In the other circumstances, the adultery has got to be proved beyond reasonable doubt. Now that law came into existence where in 55 New Law Report at page 410, in the case of Jayasinghe versus Jayasinghe, in the District Court of Gampaha, it was said that if you have cohabited, a married party had cohabited with another person, had had sexual intercourse as per se, you will be caught for adultery. Adultery is not a criminal offense. Adultery is only a civil offense to a particular party. There is no law in Sri Lanka that adultery is a criminal offense. But having a marriage done twice, once you are married and you are entered into another marriage, that's a bigamous marriage, that is a problem which you will be charged in the magistrate's court. But there again, if you feel that you were not married, although you were married, and you get married for a second time, you can go to the case, and if you can prove your innocence on that matter, you can get out of the situation of a bigamous marriage.
There is a curious question relating to that as well, sir. When it comes to the approach to affairs, extramarital affairs and divorce, and as you mentioned, the bigamous marriage as well, is there clarity on the law where the irretrievable breakdown of a marriage is what causes the courts to provide for an annulment of said marriage? Can you please explain to us how exactly courts can come to the final decision that this is not something that is salvageable, where that decision is given?
Yes. You asked the first question about adultery. In adultery, just because you are seen with someone or going out with someone or texting messages and sending good morning and good night messages, don't come to an extramarital affair which leads to adultery. To be having an adulterous relationship, you must be sleeping with that person. So the 4 New Law Report in 1904 has set out that you must give the date and the place of the adultery. You can't say in general. Now coming back to the second limb of your question, the law relating to this is clearly set out, where if you can't prove it beyond reasonable doubt, as set out in case law 55 NLR page 410, you can't prove adultery.
Exactly.
So it is a very difficult act to prove when you are in court, to prove on the grounds of adultery, unless the child's birth certificate has the adulterous father's name or the mother's name and the other person. It's very difficult to prove.
There is the question that arises when it comes to the act of adultery, that is, it has to be proven, of course, and there's always that concern of not having clarity relating to proving adultery. As you mentioned, now if it's not on the birth certificate, if it doesn't look like it's set in stone, then it's going to be very difficult to actually prove in court. What are the remedies or maybe the justice available for spouses that may suspect or may have even a convincing argument relating to their spouse that has committed an act of adultery?
Most often in practical situations we see SMS messages and maybe online messages via computers, but those to be proved in court, it's difficult because the SMS messages don't amount to adultery. It's only, I would say, amount to flirting. So if you can circumstantial evidence show that necessarily these two parties, one party has got to be married for adultery, are going out, and the SMSs show the date and place on which they have committed adultery, that may give rise to some information to fortify your case on adultery. But the actual truth and fact is that you have to catch them in the act, or you should have to be able to prove. So you go into a hotel room and both have signed their names in, or that's enough evidence to prove that there has been adultery committed there.
Now there is this area of curiosity that I wanted to breach with you as well, sir, relating to the legal acknowledgement of a marriage as well, the concept of habit and repute. Can you give us some insight into what this legal concept means for marriages in Sri Lanka specifically?
Those days, in the olden days, there was a marriage of habit and repute, where one person used to live with another person. Sometimes if they were married earlier, the sister died and he lived again with the younger sister. So the people in the area and the elders in the area have recognized them to be a couple together. So therefore, there are under our General Marriages Ordinance, there are two types of marriages, the normal registered marriage and the marriage by habit and repute. Now when you take into example the wording habit and repute, that is, there has been a habit that you are habitually living with that person and you are cohabiting with that person. So that is the concept of habit and repute, which we don't see very much now in Sri Lanka, because that was in the olden days in the villages. But maybe a new trend might set up with all these condominiums coming up and people living together, that also, like in overseas countries, by habit and repute, they might be living together as husband and wife, and the public people accept them to be a couple of the same. So that may rise to, in this context of today's advancing society, that they can be termed to be a marriage between them as habit and repute.
So moving on specifically when it comes to situations of weddings in itself and signings and registrations that take place, the breach of promise of marriage is something that's a little bit confusing, to say the least, specifically when it comes to how it can be legally considered an offense, or is it not. Can you give us some clarity and some direction into what exactly amounts to a breach of promise of marriage, and also specifically relating to instances where individuals may have sent out wedding invitations in order to announce a specific date, but actually there was no marriage taking place. What's the law around that, sir?
Yes, we see in today's context a lot of SMSs going and love letters going up and down and roses going up and down. Now those cannot be constituted to be a breach of promise of marriage. A breach of promise of marriage will be where one writes whatever he is writing or she is writing, saying by this date, there must be a specific date on which you are promising to marry. I will get married to you, or I love you and I am going to get married to you, are not words that can constitute breach of promise of marriage. And if a married is a gent or a lady who is already married tells to another opposing sex, I am going to marry you, whilst being married, there is absolutely no breach of promise of marriage, because the opposing party knows that you are already married. So whilst knowing that you are already married, there can be a promise to marry. The breach of promise of marriage comes in the law of contract. There must be an offer and an acceptance. So when you see that the offer and acceptance and the intention to create a legal relationship in a contract, there is the binding contract of a promise to marry. So if you are not set out a date on which you are going to promise to marry, it will not constitute a breach of promise of marriage. And if you have put a date that you get married to someone and you breach that promise, you can be sued for damages by the opposing party. That is why when you ask the question, once you send out your wedding invitations, whether you can be liable if the wedding doesn't take place for breach of promise of marriage. The sending the wedding invitation connotes from both parties on a specified date that they want to get married. So if they do not stick to that, either party who is aggrieved by that can file action for damages in the District Court of Sri Lanka.
Exactly. And relating to the fact that marriage dissolution and divorce in itself is a very complicated issue, but there's often the conflict of not being able to be granted an amicable separation. Where exactly does the law draw the line when it comes to that kind of situation? Because of course we understand that our courts are not geared towards automatically promoting and being supportive of a marriage dissolution, and there are steps that have been taken leading up to maybe the decision that it's irreversible and irrefutably damaged. But before that scenario occurs, if there is a spouse that is refusing to provide an agreement to dissolve the marriage, how exactly the Sri Lanka's courts handle such a situation?
Yes, in our divorce law we have where you call for the family counselor's report. As soon as you file action, you can ask for the family counselor's report. So that's the stage where counseling can take place and reconciliation can take place. But if you want to cut short to that procedure, you can also say in your plaint or in your answer that there is no settlement in the offing of both parties, and therefore we could straight away go in for the divorce case. So the grounds for settlement is now embodied in our law, where you have to go before a family counselor and see whether things could be adjusted. And if you can't, then you go before the law. Now, where you say that both consenting parties want to get divorced, that's a very simple method, because you can either prove or state malicious desertion on one part, and our Civil Procedure Code has a specific section called Section 72, where the opposing party, once the plaint is filed, doesn't have to even file an answer. That opposing party has to admit the averments in the plaint and sign that, and that has to be countersigned by the lawyer. So that amounts to be like an answer, but it's a consent between the parties in granting the divorce, and most often it is on the grounds of malicious desertion.
The entire concept of malicious desertion as well is kind of confusing as well when it comes to the layman to understand exactly what happens when a spouse has abandoned a marriage or there is no communication or contact. What exactly is the law in relation to that? Because it's not like we have an open line of communication. What happens there, sir?
In that context, our Section 40 in our Civil Procedure Code, which says when and where the cause of action arose, when and where and at what time. You have to give a date on which you have gone out of the house or left the matrimonial house, never to return back. It's called animus revertendi in Latin. So if you can prove that that person has gone out of the house, never to come back, then there is a grounds for divorce. But sometimes people think that going and making a statement in the police can resolve the marriage. That is only a police statement is to see what are the rights and duties of a person if there is any criminal act taken place. There is a presumption or a notion which is wrong that once someone leaves the house, you must run to the police station and make a police entry that you have left the house. There is nothing like that. You can leave the house today and tomorrow you can file action. There is no time bar. So in that context, once you are leaving the house, the words animus revertendi, that never again you are going to come back, is the most important legal point that you should have in your plaint.
Exactly. I want to get to the specifics relating to the current context as well when it comes to the internet sphere, and also what we can expect to see moving forward with reforms and maybe a change in the landscape of the legal landscape of marriage and marriage dissolution, and how we can see it evolve moving forward. But before we get into any of such specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this.
Hello, my name is Anand Tusharan and I'm an undergraduate at NIBM. My question is on the current context. How does the modern age handle divorce?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Ian Fernando, attorney at law, and we're speaking about marriage dissolution and also the aspects surrounding and leading up to marriage dissolution as well. Thank you very much for the previous segment, sir. We got a lot of insightful information relating to how the day-to-day occurrences of a marriage and its annulment can be navigated by individuals. Now, when it comes to specifically the fact that an annulment, not an annulment, but more of a dissolution, an agreement to participate in a divorce must be provided on both ends. Or is there some sort of mechanism that the court can employ if there is a continuous refusal by one party to provide an acceptance for divorce? What happens in such a scenario?
You spoke about annulment. Annulment comes only in a situation where the marriage is not consummated, not in a normal divorce case. That's a different type of segment in the law, where you say that the marriage is only restricted to the piece of paper, the marriage certificate, and therefore parties have not cohabited, and therefore you go for annulment. The other context that you are questioning me is on how and best the procedures that are laid down. In that context, the normal procedure goes through where you can, if you want, sign an antenuptial contract. Antenuptial contracts in Sri Lanka are not very much seen. That is regarding the property you own, whether parties how will divide it in a case of divorce. So those agreements are still yet in the offing, but it is possible in Sri Lanka.
Prenuptial agreements
are possible in Sri Lanka.
Right. I think that is a very important point as well, specifically considering the financial aspects are not quite explored before the signing of a marriage certificate or registration of a legal marriage. Specifically speaking about international contexts. Now, sir, I understand that our marriage laws vastly differ from the rest of the world as well, and we have multiple systems that are in place that govern certain types of marriages as well. How exactly do we compare on a global footing relating to other countries? Are we on a more of an equitable level, or is there maybe improvements or reforms that we can see moving forward?
We are on a very strict level. For example, in Japan, if you are a prostitute and it's your job, so you are definitely committing adultery, that is allowed in their law. So you see to which extent an advanced country has advanced themselves. So we are still back with the marriages ordinance, which is there a long time ago, where we only recognize 3 types for divorce. So we have a long way to go with the inflection of time and with the advancement of technology and certain aspects, maybe that our law will increase. Now we recognize foreign judgments where people have got married abroad. They need not come to Sri Lanka to get the divorce. There is a mechanism now and a new act that has come into play where foreign judgments regarding divorce are recognized in Sri Lanka. So it's basically a procedural aspect where you file the papers under summary procedure and you can get your divorce.
So there is no hindrance.
There is some advancement.
There is some advancement, yes. But we can expect to see more development moving forward, hopefully. Relating to the consent to marriage, specifically when it comes to, well, marriage, while it is legally between 2 individuals, there's always the involvement of families. Now, when it comes to the consent that can be provided for marriage, what exactly does the law dictate for individuals that may seem to have had a coercion into a marriage agreement, specifically through family pressure?
The degrees of marriage and the age of the marriage is set out in the General Manager's Ordinance. It was earlier, I believe, 21, but it has now been brought down to 18. And between 16 and 18, only if the parents consent that you could get married. So that is how, regarding the age of the marriage, that is set out. Then there are certain prohibition degrees of marriage. That is, for examples, of the same blood. If in a family, the brother and sister can't get married. If he has a stepsister or stepbrother, also can't get married. That is of the half blood. And those criteria regarding your prohibition of degrees of marriage are set out in our marriage ordinance. Also, health-wise and genetically wise, they are prohibited because they don't form a proper marriage of producing a proper child which is healthy. That is why they have been prohibited.
Moving forward, sir, I want to ask you about the specific issue that occurs when divorce happens along with children in play. I wanted to ask you about maintenance cases as well. Now, we understand that during a marriage dissolution, there has to be some sort of overtaking of custody by a certain aspect, maybe shared custody. Can you walk us through the law that's already in existence relating to how children are handled in a marriage dissolution?
Yeah, in a marriage dissolution, children who are under 7 years, which are called culpa incupex in Latin, naturally go to the mother, under 7 years, whether female or male. However, if you can prove that in the best interest of the child should be in the father because the mother is a prostitute or a drug addict or a spendthrift or a rogue or whatever it is, which is not very conducive in society, the father can make the application to get over having the custody of the child over the mother. Normally, the father is the person who will have the custody, but court most often, for practical reasons, hands the children to the mother, because the mother's love and care has got to be there. Then when you talk about shared custody, the court will go into inquiry to check under sections 621 and 22 of the Civil Procedure Code who should get the custody of the child and how the arrangement will happen. If both parties are contesting, both parties will have to give evidence, and then thereafter only court will come into a decision as to which party is better to have the child and for how long. So sometimes we see that during the weekdays the mother has the child, and during the weekends the father has the child. And sometimes it's so complicated that they really fight tooth and nail how they are going to divide this week on the excess. So that the court intervenes into that and try to see a settlement. But if there is no settlement, goes to an inquiry of leading evidence to find out how the child's custody should be divided between the parents.
So it is a constructive issue where the courts have to basically be very hands-on with their approach as well in order to determine how custody should be shared, or is there some sort of already set maybe a sequence that can be provided by the courts as a default?
The court is deemed to be the upper guardian of the child. So therefore, the court can take whatever decision the court wants on the facts placed before court. So court will naturally go through, if the court needs to get more information, he will call for a report from the probation officer. The probation officer will go and visit the child, visit the parents, both parties, see how they are living, their living conditions, who can provide a better environment for the child, for the upbringing of the child. The probation officer's report will be taken into account, whilst the court will make order, even after an inquiry, as to who is allowed to have the access and to nurture the child during the pendency of the divorce case.
I also want to ask you, sir, relating to maintenance cases as well, issues when it comes to maintenance, is a divorce necessarily needed for filing maintenance cases in Sri Lanka's law?
The Sri Lankan law sets out that if you are separately living, then you can file a maintenance case. There is no need to be a divorce case to file a maintenance case. So many lawyers tactfully first file a maintenance case to feel the pulse of the opponent client before they file a divorce case. The maintenance case goes sometimes concurrently with the divorce case, and the maintenance case can be in the magistrate's court, or it can also be in the civil court under section 614 and 15 of the Civil Procedure Code. In construing both those matters, once the divorce case is over, the maintenance case, unless you keep a specific area in the consent decree that the maintenance case will run in spite of the divorce case being ended, otherwise naturally the maintenance case get ended, because you have been granted permanent alimony and your children also may have been given some in the form of settlement sometimes. Then the maintenance comes to a halt. But you can set into an agreement in the divorce case where both parties are agreeing for the divorce and who is to pay whom or whatever, and the maintenance case to run until the child is 21. Earlier it was 18, now it's 21, and they have further increased it to say 25. That is in the context where the child has not finished his or her first degree. So if the child has not finished his first degree, maintenance can be called for, and at that time even the child can file a maintenance case against the parents. A child is entitled to file a maintenance case, being a major, that he need to be looked after until he finishes the first primary education or the first degree of the first instance.
Right, and now it's a bit of sensitive area that I wanted to breach on, but it's a little bit necessary to understand as well. When it comes to violence within marriages, of course, it's one of the leading reasons as to why we can see divorce settlements even being called for. How exactly do the courts handle violence that has been reported in a marriage institution? What are the legal repercussions, or maybe the injunctions that can be provided? What do the police do if there is a report of violence within a marriage?
I think if I recall, our new law report 22, so far back as that, has spoken about parties having violence between each other, but I can't give the correct reference, it's not in my memory. But violence between parties are to an extent in a marriage considered. But when the violence goes over and above that limit, we have the Domestic Violence Act, which provides you to get an order from court, a protective order from court, to not to allow one party to come into the house. You may be the owner of the house, the husband may be the owner of the house, but the wife can get a protective order not allowing him to come to the house. And that protective order will be made a permanent order only for a period of 1 year. So by that time 1 year comes, your divorce case or whatever case that you want to file will get going. And the protective order will be only enhanced after that by court on circumstances placed before them.
Right. I want to ask you specifically relating to now domestic violence in itself as well. There are court orders that can help protect the victim from considered advancements as well when it comes to such a volatile situation. Specifically in relation to how that amounts in a case for divorce. What kind of factors will be considered beyond the already existing pillars that have been legitimately recognized for the dissolution of a marriage?
Domestic violence can lead to a situation where you can show that he had to or she had to leave because of constructive malicious desertion because of domestic violence. So you have to fine-tune your case right up to that point, that there are a series of events, not one offhand of event. There are a series of events that caused the person to leave the house. So then of course that domestic violence and whatever police entries that you make can be taken into account. But all those police entries made and child protection authorities, they will have to lead evidence to satisfy the court that there was an environment not conducive for the children to live. If it was an environment that was conducive for the children to live, although the parties are fighting each other, that's a matter for court to consider, so long as the children have not been affected.
I want to speak about the future of the law relating to marriage dissolution and also what protections are awarded and what we can see as a change in the legal landscape as well for divorce specifically. But before we get into any related specifics, let's take a very short commercial break once again. You're watching Law, Land and Liberty. We'll be right back.
Hello, my name is Menuka Vijayasinghe. I'm a preliminary year student from Sri Lanka Law College. My question is on abuse. How are cases of divorce in such situations carried out?
Welcome back to Law, Land and Liberty. We're in our final segment in discussion with Mr. Ian Fernando, attorney at law, relating to the dissolution of marriage, divorce, and also the related aspects of it as well. Thank you very much for the previous segments. I believe we got a lot of contextual understanding into the institution that is marriage and what happens during its dissolution. Now, we were just breaching, before we went into the break, a very important area of maintenance and also violence, specifically relating to the products of a marriage, the children. Can you please explain to us further relating to maintenance cases and the filing of such maintenance cases and also the entire process leading up to it? How exactly does it correlate with the divorce proceedings? How does that work?
Yes, our maintenance ordinance is also a very old ordinance. The maintenance ordinance sets out that when you are going to be divorced or when you have lived apart, that either party who has lived off the other party, that the same standard should be maintained. For example, if the wife has gone off and the wife has provided more money for the husband to live and she is having a top job, then the husband can file a maintenance application against the wife, but he to be maintained at the status where he was before she left him. So that law also has been recognized in Sri Lanka by case law, and in doing that the court will go into a finding how much is one's salary who is going to maintain the other party, and on a rough estimation take 3 years into account. For example, if you are earning 10,000 rupees a month, 3 years your total will be 360,000. Then you divide it by 36 and get an average of 10,000. That is the month. The courts have discussed, and it's set out in our law and the Maintenance Act, that the guilty spouse is entitled to not less than 1/5 of that earning, of the average salary. So if it's 10,000, if it's 1/5, that party is entitled to not less than, more than 2,000 rupees. So the maintenance also will go into account to see your assets and what your incomes are and what are your fixed deposits are, how much you can earn, how much was the living standard. For example, the person who has been dropped to school by car need not necessarily go walk into school by bus. Some mode of transport like a trishaw or some method should be allowed to drop that child, because that's the comfort that the child had at that time. So going further, even their sports, their extracurricular activities, if they have not done or they have been doing at that time, or that extracurricular activity need to be done according to the requirement of the school, the either party will have to provide for that. So court will call upon most often the father, who is the breadwinner of the family, to provide for the child to play school cricket or rugby or to enter into some drama competition. They will ask the father to provide for that. So those factors also taken in extracurricular activity of the children in the children's maintenance when court orders.
Exactly. And related to children, a question of curiosity, sir. If there is a child born illegitimately to the marriage, outside of the institution of marriage, how exactly does that play into the testamentary issues as well, and maybe the entire inheritance issue if there are illegitimate children involved during such a proceeding?
The normal concept is the father makes no bastard. That's a concept. So then if the father dies and it's an illegitimate child, that child will not inherit anything. However, if the mother dies, it's the mother's baby. The father is the person who has entered the mother, and it's called the vessel. The mother has nurtured the child. So mother's whatever inheritance will go to the child.
So there is an understanding in the law when it comes to how to divide assets as well following death, or maybe even just how the dissolution occurs. I want to ask you specifically related to that as well. Are there instances where illegitimate children via the courts have been awarded any sort of inheritance from the paternal side? You mentioned that they are not owed any outright, but have there been instances in Sri Lankan law where they have maybe requested via courts, or has there been any sort of precedented case law relating to it?
No, it happens this way in practical situations where the father who has the illegitimate child will provide something for him or her in his last will. So that is perfectly okay. And there are some situations where that illegitimate child, if by chance, say for example the wife, the father has died, and this gentleman who produced the illegitimate child can get married to the particular party. And then of course the legitimization doesn't take place, but if he does something like an adoption, you might be able to get his name into the birth certificate as a father.
So
after the marriage.
So there are means by which this situation can also be considered. Yes. Now, relating to a very curious question I have, when it comes to the current status of Sri Lanka's marriage dissolution laws, when it comes to what we can expect moving forward in Sri Lanka's legal landscape, I'm sure we already have quite a strong system in place. But in your opinion, sir, what can we expect to see in the future moving forward? Because there's always that heavy influence of the internet, and now how relationships are carried out in the modern day and age is also different. We just spoke about how there could be no actual legitimate marriage, but there's a promoted culture of living together, and maybe it doesn't look like a marriage in the eyes of the law. But what can we expect in terms of the legislation moving forward for married couples in Sri Lanka?
Yeah, what you're saying, living in separation. In fact, a little before I came for this interview, I was called from a particular party in UK and questioned that if you live separately for 7 years, won't that be considered separation? That is called separation mens et thero, and whether it won't be recognized after 7 years to be grounds for divorce. That was there those days where air travel was limited, sea travel was limited. If you don't see your husband for more than 7 years and you are separated, you can come under mens et thero and file action. But that is now done with. So if you are separated, there is no law unless you file a divorce case and get yourself legally separated. The law of separation is not seen today in Sri Lanka, and I think, if I am right, it might be abolished, because our way forward in those matters will be that we recognize living together, which is recognized overseas. In countries like Holland, if you are living together and you have produced a child, you are given accommodation, you are given a flat. So we have not yet gone up the ladder to come into a situation for the advancement of our law, as we are not still in the era of living together. Maybe not in our era of our livelihood or our living era that we might see this, but with that development of living together, which is, we are in a Buddhist country, which will be very difficult, there might be advancement of the procedure of law, because then there is a marriage by cohabit and repute, and then people will look into whether why you have not registered, and then how divorce can take place, may be the way forward.
Exactly, and unfortunately we have come to time when it comes to this specific discussion. But before we conclude, I'd like to ask you, sir, if there are any specific words you'd like to leave with viewers of the audience that could be undergoing divorce, or maybe an individual that is in such a precarious position. As a legal professional that has handled these kinds of situations moving forward, how exactly, what kind of advice would you give to someone that's maybe going through a proceeding currently?
My advice is never divorce your partner, because the children will suffer, and the children need the father and the mother. Maybe that the father is not in the house always, but there is a hand telling the mother what to do. So once anyone divorces, the whole family goes astray. Sometimes I see in my practical cases the children do better than what they would have ever done, because they want to strive hard, work hard and do better. But still, a family means never to be broken. There is a saying, what God has put together, let no man put asunder. That proverb is existing for so long because there is a truth on it that the family must stay together.
All right, I believe those are some very insightful words that we can leave our audience with. Thank you very much, sir, for taking the time to come down to our studios once again to actually explain this very complicated topic to us, despite having previous episodes as well. It's very important for us to cover all the aspects, especially not just the legal dilemmas, but also the day-to-day expectations. So thank you very much once again, sir. And we leave you tonight with the words of psychotherapist Esther Perel. Love rests on two pillars, surrender and autonomy. Our need for togetherness exists alongside our need for separateness. That's all we have for you tonight on Law, Lad and Liberty. If you had missed any of our programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherthanenglish. And please do share your thoughts and feedback with us through email at feedback.8024english@derana.lk or via WhatsApp at 076 805 7933. Thank you for watching. Have a good night.